And we're live. And I have no idea why I am large and Shane Harris is small.
Wait, that's
Um,
strange.
yeah,
Is
is
this a
that something?
metaphor?
I don't know. It's actually upsetting. If you talk, do you become large?
Well,
Or wait,
now we're
I
the
was
same.
pinned for some reason. I must have accidentally hit
Oh.
pin. And that's what happens when you stay up late writing and you wake up thinking that count one is about Andy. You go to sleep thinking that count one is probably about Andy McCabe, and you wake up with a flood of blue sky material from Anna Bauer suggesting that no,
Plagued by
maybe really
doubts.
probably about Dan Richman, and you can't decide, is this like they're making a fucking soap opera about my friends and you're not really supposed to ask, like you can't like call up Andy and Dan and
Right,
say, hey
you?
guys, which of these is the one
You
about,
can tell
is it about
me, I won't
you,
tell.
or is it about you? You can't really do that, it's kind of rude. And by the way, maybe that maybe
It's
you
not a good
can
idea.
do that. That's the other thing. Are you allowed to, when you read
Mhm.
an indictment that is so fucking vague that you actually, as somebody who knows all the people in question, can't figure out what it's about, are you allowed to just call them and ask?
I think
Um,
you should. I mean, I have read fortune cookies that are more descriptive than this indictment.
all right. It is Friday, September 26th, the year of our Lord 2025. And because it is the year of our Lord 2025, that means things are fucked up. It is 8:02 a.m. Eastern Standard or Eastern Daylight Savings Time. Look, guys, I know that you think things are bad, and we're going to get to all the ways things are bad, but I have something to say first. The sun is shining. The birds are chirping. It's going to be a great fucking day, and you are watching Dog Shirt TV, and I don't even need the cactuses to say this. It is a goddamn revolution in morning television. And one of the revolutionary features, and there are many, is that I stayed up until some ungodly hour last night reading the Comey indictment, which is like 2 paragraphs long and didn't really take very long to read, and trying to figure out what it's about. And that actually took a long time, and I didn't succeed because it's completely opaque what it's about. I've never seen a charging document that gives less information about what it is charging. And it occurs to me that that is not just a metaphor for something, it's really what this is about, which is the one thing that is clear in this indictment is that Jim Comey is being charged for being Jim Comey. And that is a clear as day allegation in the indictment. It is the only clear allegation in the indictment is that you, motherfucker, are named Jim Comey, and I hate you. And I appointed a prosecutor who is willing to be an expression of my hatred for you, and that turns out to be the highest calling of the U.S. Attorney's Office of the Eastern District of Virginia. Um, Look, I don't know what to say about this. I expected to have a whole lot to say last night because I was going to dissect the indictment in depth, and I was going to stay up however late it took to do it. I can't even tell who is at issue in count one of the indictment. Is it Andy McCabe? Is it Dan Richman? I have a lot to say if it's Andy McCabe, pages and pages and pages to say. I have a lot to say if it's Dan Richman. Pages and pages. I'm not playing an either or game with you, Lindsay Halligan. Make your factual allegations and I will respond to them. I know this case better than you do. I promise, like a lot better. If I had been allowed to present the case in the grand jury, which of course I never would have done because it's unethical, um, uh, it would have been done better than I'm sure you did it yesterday. Yeah, you were in the grand jury for 4 hours yesterday. There's not, I mean, come on, let's be serious.
4 hours.
Oh, that's what I hear anyway.
A long time for 2 paragraphs.
Yeah, it's a lot of time to get 2 paragraphs and have a third rejected.
Right.
Right
Maybe there was a
now,
healthy discussion.
let's talk about grand count number two, because count number two may be entirely redundant of count number one. It's reformulated as an obstruction case. Count one is he lied about somebody,
And to be
something.
clear, for those following along at home, you mean count one and count two as indicted, not in the original
Correct.
indictment, which includes count one and then count two and then count two.
Right. So count two as indicted
Yeah.
um, is alleges that he somehow tried to obstruct the congressional committee by making false statements and false and misleading statements. Count one is about an allegedly false and misleading statement. Number one, only one, singular, but we can't tell who it was about. Was it about Danny or was it about Andy? We're not sure. Count two is alleged false statement. So we got to get a second false statement, or at least a misleading statement in there. Totally unclear. And we have to have intent to obstruct the committee.
That's a question.
Yeah.
Is it possible that by saying statements she meant to incorporate the original count one and count two, and then they just didn't change the wording when they?
Well, so why would you indict the same alleged false statement
No,
twice?
I'm saying that when she originally files the indictment, there are two charges of lying. There's the one that involves did not remember being taught of person one's approval of a plan concerning person two. The grand jury doesn't take that one. But then the next one is the one that we can't figure out if it's Dan Richman or Andy McCabe. And then was what now is count two, it actually is the third alleged count in the original grand indictment. Would that have been to incorporate the statements previously enumerated?
Why you would want, if you've indicted them already individually, why you would indict them again if it's purely redundant of I don't know. But then again, we're
Okay.
dealing with somebody who doesn't have a freaking idea what she's doing. So
Yeah.
I'm not sure we know. Like, anyway, the point is, I have almost nothing to say about this indictment substantively, because I literally can't read it. I can't figure. I mean, I can read it. I can't figure out what it is actually alleging Jim Comey did. So that makes it a little bit hard to spend an hour talking about it. It's 2 paragraphs that I can't make head or tail about. And by the way, anybody who tells you they know what it's about is full of shit.
But you do have an idea what it might be about. And, you and Anna wrote pretty extensively about that. Like, I think it's either Dan Richmond or it's Andy McCabe, right?
Right. Well,
One
count
of those
one
two
is
scenarios. It's
count,
leaking.
but count. Then what is count two?
Before you talk about counts, can you talk about the report of the failure to bring a count?
Yes, I can tell you exactly what I know, which is that there is one charge that the grand jury rejected, and so batting 333 in the major leagues is really good. Batting 333 in before a grand jury as a prosecutor is catastrophically bad. The proper average for counts that that you present to a grand jury that they indict on is 1,000, and if you are having grand juries reject any charges that you are presenting, you are deficient as a federal prosecutor. It simply should never happen. And I challenge you to find me a federal prosecutor, current or former, of any reputation who will disagree with me about that.
I hope that's
Um,
a really clever 1001 joke, but or
it's
um,
not,
but
because you
my
can't
question
bat
is
1,001. But what is your question about the rejected charge?
well, my question was more about the document about the rejected charge, the report of a grand jury's failure to concur in an indictment, which notes that this record is being filed with the court clerk and will not be made public unless the court orders otherwise. And I've never seen one of those before. And I'm a little puzzled that a judge would have acted so quickly to have unsealed that document.
So, yes, so I do not know the answer to the question how procedurally that happened. And I don't know whether it was done by the magistrate or
And
by
could it
a
be a
judge.
mistake?
I'm sorry?
And could it be an error?
I can't imagine a court error happening in a case of this magnitude. But sure, it is 2025, and that means anything can happen. So look, I don't know. I assume that somebody at the court with authority to unseal it, because there's no suggestion. I haven't looked at Pacer and seen whether it's on the docket, but I assume it is on the docket.
It is.
So it was not leaked, it was unsealed. And that means I assume it is still in front of a magistrate judge. Or has it been assigned yet to?
It's a dash CR criminal case, and it is
Okay.
assigned, and everyone's reporting it's an Obama judge, I guess, or I don't actually recall the judge.
Okay, so then he
Sorry, it's
unsealed it.
Michael
Um,
Nachmanoff.
okay. So look, he unsealed it, and presumably that reflects the fact that a a federal judge. And by the way, I don't know anything about Judge Nachmanoff. I've never, I don't, he hasn't been on the bench very long, and I have not dealt with any cases in his court. So I'm not in a position to talk about him. But look, when a case starts with, and he will be aware of this extrajudicially, a huge flurry of press about the president demanding the indictment of a particular individual, firing the U.S. attorney who runs the office that practices in front of you because he won't target a particular individual with a particular set of charges that are reported publicly to be deficient according to an office with which you have a repeat player relationship. So these are, you don't know the names of the prosecutors who advised Mr. Siebert that this is a deficient thing, but I promise you Judge Nachmanoff does, right? And so what before any of this happens, every judge on that freaking court is aware of the extreme procedural irregularity, all of which is bubbling in their minds. I may have to sit on the most extraordinary motion for vindictive and selective prosecution in the history of the United States. And then the first document that shows up on your docket is the grand jury rejecting one of three charges. So maybe you say, actually, that's something that should be public. That said, I have no idea. I literally did not know that was all I knew is that the document was public because I'd read it. And I didn't know Judge Nachmanoff was the judge on the case until you just told me. I haven't read any press about this. I've only been dealing with primary
Do
source
you or
material.
Shane know? Is it normal to docket these declinations? I've never seen one before, but I don't do a lot of criminal.
I don't think it is normal. Well, it's not normal for them to happen. And
Fair enough. Yeah.
so I don't know. I've never heard of one happening in EDVA. There's been a flurry of them in the district. And of course, one happened in the district in the Andy McCabe case where it was not made public. And still to this day, there is no public confirmation that Andy's case was no true build. We all know it was, but we know it was only because he wasn't indicted. Like it's a dog that didn't bark situation. His lawyers were told by the Justice Department that they were going to the grand jury, and then they went to the grand jury, and then crickets, right? So, anyway, all of which is a long winded way of saying that we're not allowed to have fun anymore, but Lindsay Halligan was allowed to have one day of fun yesterday. That's all she's going to get. And we are allowed to have Shane Harris here to chew through it all. Holly, in your absence, I usurped the role of the cactuses.
That's okay.
By
I
the,
only came because I feared you would be alone, but
there was no chance that I
I
was
could
going to be
leave,
alone.
but
But
now
you,
I'm
you are, as
interested. So
always, a sight for sore eyes on this show. And by the way, folks, if you have not seen yesterday's book club with Alicia Wanless and the estimable Holly Berkeley Fletcher, it was a
and many
riot of a
others.
it was a riot of a good time. There were laughs. We cried. We told
Alicia
jokes.
cried. I think we traumatized her with memories of her dissertation defense.
Yes, and I even teased Alicia about
She didn't cry, but
her anxiety dreams. Um, and um, and so it was great. It'll be posted for paid subscribers only, by the way, on Dogshirt Daily later today. All right, Shane,
Yes.
what do you make of all of this? Am I being hyperbolic and because I am, after all, a friend of Jim Comey's, like whatever, maybe I'm being emotional. What do you make of it?
Well, I think I tweeted yesterday, or I blue skied, whatever we call this. Now, what do you call a blue sky post? A blute? I don't know.
I
I
insist on
just
calling
post.
it tweeting
I just say
because
post.
I don't accept that Elon Musk owns the word tweet.
Well, he
Yes.
doesn't call it that anymore anyway, so.
Well, what I wrote yesterday, off of some good reporting that Catherine Folders at ABC had done with her colleagues, where they found this is the relevant paragraph says a former insurance lawyer turned White House aide with no prosecutorial experience, Halligan has been advised by career prosecutors in the U.S. Attorney's Office that seeking the charges would violate DOJ policy, raise serious ethical issues, and risk being rejected by the grand jury, sources said. Well, they were right on 1 out of 3. She plans to pursue an indictment anyway, carrying out the clear mandate she received when she was installed into the position over the weekend, sources said, to which I commented, perhaps Halligan is not concerned about keeping her law license, but her new colleagues at the Justice Department sure seem to be. Look, I mean, you and Anna wrote this, I think, pretty forcefully and eloquently in your Choose Your Own Adventure piece, which was great. This Halligan was hired for this job to do one thing, and she did it. And she put her name on this indictment that I think, as I joked, before we came on, I've seen fortune cookies that are more descriptive. So she did her job. Whether she faces disbarment actions down the road is, I guess, a different question. I'm a little curious, just as a psychological matter, why you would choose to do something like this. Jim Comey doesn't seem too worried. I think he probably should not be. I mean, the case just seems like a dog, not to invoke the mascot of this august show in a pejorative way. But like, whether this count is the Dan Richmond thing or the Andy McCabe thing, I think the facts look really good for him. I'm more persuaded that the Andy McCabe thing, and we can go into what it is if you want, is totally a dog. Maybe the Richmond thing has some potential there. I don't know, but
Yeah, but
sure.
it has a deep problem of which Lindsay Halligan may not be aware of the magnitude,
So
which
this
is
is
there's
good.
no way to do it, I don't think, without calling Dan Richman and putting Dan Richman on the stand to testify. First of all, Dan Richman is smarter than Lindsay Halligan by there may be 100 IQ points separating them. I mean, this is this is a serious guy. He's also very quick-witted, and the idea that, and we know from the Arctic Haze papers that after investigating this during the first Trump administration, there was a decision not to proceed with anything because it wasn't, first of all, the premise that there had been any disclosures anonymously was not obviously true. And secondly, the idea that Dan was acting at Jim's behest rather than on his own in various interactions with the press, of which he had many and was never, never made a secret of, is not at all clear. And
No.
I will just say that the New York Times reported after Dan was interviewed this time around, that his interview was unhelpful to prosecutors. And
Just why they didn't indict.
let me try to decode that for you, because I know Dan very well and I know the underlying story very well. I mean, the issue relates to, I mean, look, I know these are facts with which I had some peripheral involvement. Remember, Susan Collins in public in a hearing confused Dan Richman with me.
Yes.
Right.
So we,
And yeah, we even kind of look a little bit alike. I mean, he's a bit older than I am, but uh, it's like these are facts that I played a small role in, not in the specific disclosures in question, but there were two people who were doing kind of what people think it was public media liaison work for Jim, and was in fact, at least in my case, initiatives of our own. And
yeah.
I am confident that if you put Dan Richman in front of if Lindsay Halligan puts puts him in front of a jury, in order to prove that Jim was lying in 2017 before Chuck Grassley, and then was lying again 5 years later when he stood by that. I promise you, without knowing the details of Arctic Haze any better than the public record is what it is, and there's a lot of redactions in it, and it refers to a bunch of classified documents that I have never seen. I promise you that is going to be humiliatingly bad for whatever prosecutor has to do a direct. You won't need to do a cross-examination of Dan. He is a careful lawyer who will not have crossed lines, and he will be able to tell his story in a way that is humiliating to a prosecutor. And that is, I think, what the New York Times was reporting when it said he had an interview that was not helpful.
I
I have a
think that's right. And I think that does not matter to the one person who is important in all of this, and that's the president.
I
Right?
think that's right. I think that's right.
I have a
None of
question.
everything that's going on right now is purely designed to allow Donald Trump to talk about Jim Comey, who he called a sick person, I think, as of yesterday, for being indicted. And if a jury finds him not guilty, he's going to say the jury was corrupt, right? I mean, the ending is already, whatever the ending in the Choose Your Own Adventure is, it almost doesn't matter for him. It matters a great deal for Lindsay Halligan. I think it matters some for Jim Comey and the members of the juror whose time are going to be wasted. But it doesn't matter for the narrative that he's telling. And she has just given him precisely, Lindsay Halligan, what he wanted, which no other prosecutor, including those who were pretty friendly to his policy agenda, would do. And I think that's, I don't know what her reward is going to be for that. I would presume there will be one. But this is about narrative. It's not about the law.
I agree with that entirely. And I will just say that any prosecutor who is willing to set foot in federal court on that principle should not merely be disbarred, but should have contempt issues.
Yeah.
And you know, I think Lindsay Halligan. I don't know anything about this judge, and I am not. And as you and I discussed last night, Shane, and as I wrote briefly in my column yesterday, I'm not sure whether the flaying of Lindsay Halligan will be the priority for the defense, or whether Jim's priority will be simply establishing that he is not a liar and didn't lie. Those would require very different defense strategies and approaches, and I don't know which one they will go with. I will say that the um you know, if they were to make this rather than a referendum on Jim Comey, a referendum on the prosecutorial practices that Trump is individually demanding of individual line and career and political prosecutors. I don't know that I agree with you. The problem is that Trump might not care, but that would be the most powerful vindictive prosecution motion in the history of the United States.
Yeah, and maybe Jim will feel strongly that that needs to become a matter of public record to
Right.
do that as a rebuke.
Did you see the video?
I'm sorry?
Did you see the video he released last night?
Yeah.
I did see the video, and it's germane to exactly this question. So, he, on the one hand, says, my heart breaks for the Justice Department. Remember, Jim was, among other things, the Deputy Attorney General. He was also the U.S. Attorney in the Southern District of New York. His lead lawyer, Pat Fitzgerald, was the U.S. Attorney in Chicago. The other lead lawyer, David Kelly, as well as Dan Richman, by the way. Dan Richman, the troika of Dan's obviously not representing Jim now because he's a witness in this case. Well, he has been a witness in the investigation and maybe a witness in any trial. But the three of them, the troika of Richman, Fitzgerald, and David Kelly, were all AUSAs together with Jim in the Southern District of New York when they were young prosecutors. That's how they know each other. And the amount of legal talent in that group is, like, Lindsay Halligan is not going to have the best of EDVA at her side when she litigates this. By the way, look for a big purge to happen which has already begun at EDVA over the next few days. A lot of people are going to quit. Some people are going to get fired. But in any event, the EDVA will, as Trump might say, not be bringing its best to this. They're going to have trouble getting people to sign pleadings. Comey's legal team is of extraordinary talent, and this is going to be a bit of a mismatch just in terms of the ability to, the weight. We're going to be operating in different weight classes. Holly.
Yeah, I had a few questions. First of all, to your point that people are going to start resigning and being fired, I saw a post on Blue Sky last night that Comey's son-in-law was in the EDVA. Is that right? And he has either quit or been forced to resign.
He's quit.
He quit. So look, I mean, Comey's, yes, Comey's son-in-law. I don't know if his name is public. I don't want to make it public.
It is because the letter is all over social media. So
Um, yeah, so I believe he quit immediately on
I had no
issuing.
idea. That's dramatic. There's so much drama in this. Um,
You know,
Second of all, so my question, which you already addressed, or my overarching question, was kind of what Comey's legal strategy would be and should be. It seems to me this sort of safer option is just to stick to the facts of the case
no,
and to, no, you think not?
no. The safe option is to sit back, do nothing, and let your legal team litigate the selective vindictive prosecution motion. I suspect that when they actually have to articulate the facts in response to this motion, that they actually will not support an allegation under the motion, that they'll be deficient as a matter of law. And that's, by the way, one of the reasons I can go into why I think that's likely to be the case, but that that you have about 10 ways to argue that a judge should dismiss this, and each one of them will support a motion to
Oh yeah,
dismiss.
yeah, dismissed for sure, because that's their first.
That's the first thing that
Right,
would happen in a normal
right.
case.
So
But
yeah,
Jim, but
yeah.
Jim's video yesterday in which he said, "I'm innocent, let's have a trial."
Mm-hmm.
That's how he ended the thing.
Yeah, yeah.
Now, that suggests a different possibility, which I floated in a conversation with Sarah Longwell the previous day, which is, the Speedy Trial Act says you have a right to the Sixth Amendment says you have a right to a speedy trial. And the Speedy Trial Act seldom gets invoked because usually it's to the defendant's advantage to waive speedy trial in exchange for, sitting around getting discovery and pleading all these motions, right? You're often not in a hurry to go to trial. Well, if you are factually innocent, i.e., the indictment says you did X and you did not do X, and your whole public reputation is about your being an honest person, which is, how Jim understands himself. And it may be very important to you to go to trial quickly. And so I have no doubt that, and I say this with no knowledge, I literally know no more than is public about this. Um, and, um, and, but it may be important to you as a show of strength to say, okay, let's go to trial tomorrow. You ready for trial tomorrow? I'm ready for trial next week. Judge Nachmanoff, would you set a trial date? I'm asking for a trial date this afternoon.
Mm-hmm.
Lindsay, you okay with that? You seem in a real hurry yesterday. You okay going to trial like over the weekend? And that would be, criminal defendants almost never do that because they almost never have no exposure. But Jim Comey thinks he has no exposure. And so, and is very comfortable telling his story to the inspector general, telling his story to, Congress, telling his story to whoever. And so I would not be surprised if Jim's posture was, screw the motions practice.
Mm-hmm.
Let's, that's for people who have rights they need to assert other than the truth.
Well, and he seems to want to prove the larger point based on the video. I just didn't
Exactly.
know, like, if it goes to trial, let's say it goes to trial, they skip the motion to dismiss.
And anytime I say something like this, people assume I'm channeling something that he's said. I'm really not.
Right. No, I understand.
And I have not, I don't know what their legal strategy is going to be. I haven't asked Jim, and I haven't talked to the legal team about it. In fact, I haven't ever spoken to them.
Let's say their strategy is to make the larger point that this was a vindictive prosecution.
Yeah, that takes a year.
Who all can they bring as witnesses, and how will that play? Because they could. I mean, I asked you on text, like, can they call Trump? But then obviously that's going to be a whole like drama. Who could they reasonably call as witnesses that they would actually have to come and testify?
Well, they would have to assert, and I am not an expert in criminal procedure, um, but they would, first of all, they would have to file a motion that says, please dismiss for a vindictive prosecution. Here's the prima facie
Oh,
case.
so they would have to have that as the motion to dismiss. They couldn't make that part of the trial.
Not
as
the motion to dismiss, a motion,
motion
to
to
dismiss. If
dismiss.
you did this conventionally, you would see over the next few weeks, months, a dozen motions to dismiss. There would be, yes, John.
So I just wanted to come on to point out, because I don't think it's obvious to everyone, that motion practice tolls the speedy trial clock. And maybe that was clearly implied, but the point being, if you choose to go down the practice of filing these motions, you don't get to take advantage of the speedy trial clock.
Correct. The Speedy Trial Act, which implements the constitutional right to a speedy trial, says you're allowed a trial within a certain period for a certain number of days, unless you waive it in order to do X, Y, or Z.
Yeah.
Right?
So let's say they do. They.
Thank you, John. I just sort of assumed that, but you're quite right.
Yeah, and it's a little stronger than unless you waive it. If you choose to file a motion, then I think you don't get to have any say on the waiver. The government can say they filed a motion, they're not the speedy trial clock is already told.
Right, you got to give the court time to adjudicate the motions.
Yeah.
So my question then, relatedly, and just to clarify, so let's say they opt they want a speedy trial, they do not file a motion to dismiss, so they want a trial immediately. My question was, can they make it as part of their defense in the actual trial that this was a vindictive prosecution?
Sure. You could have a defense. You can tell whatever story you want in defense, but the defense could be Jim Comey did nothing wrong at that hearing, and you brought this case vindictively because you are a malicious motherfucker. And you, Lindsay Halligan, were doing the bidding of Donald Trump. And you might be able to call as witnesses for the defense a whole bunch of people. But you might not, because they're not probative of Jim Comey's conduct, which is what's at issue at trial. So you'd have a fight about that. In a vindictive prosecution motion, I don't think you have a fight about it, because it's probative of the question of whether the decision to bring this case was on the merits. The subject of the litigation is a different question.
And Ben, would he file that vindictive prosecution as a motion in the case, or as a separate civil matter, like seeking some kind of...
No. It's a motion to dismiss in the case. It's part of pretrial motions practice.
Okay.
So look for, if you're seeing a conventional defense, which is what the defense lawyers, I suspect, would want to do, because the advantage to the conventional defense is it gives you every possible chance to win. You can win on this motion. If you don't win on this motion, you can win on this motion. If you don't win on this, and by the way, all the motions avoid the vagaries of the jury process, where, you get 12 people together, they can do anything can happen, right? So you have many, many ways. So look for a motion that says, hey, the facts, even as alleged, don't state a claim under... Yes. Don't allege. That would just be a motion of a deficient indictment, right? Could file that. And the second is, but in order to do that, you would need some kind of bill of particulars, right? You need, because right now you can't even figure out what he's accused of.
Right.
And so, there's a lot of different possibilities, and a good criminal defense legal team will exhaust all of them, which is why it would take a long time. The one I think that would be dramatic, if you're Jim, the one you would want to win on is if it's not going to go to a jury, right? If you're going to win on the motions, you would want to win on, you haven't even alleged anything,
Yeah.
right? Um, uh, and
Is that on that point too? And this will be helpful to people. We're talking about how vague this indictment is. Does that mean that like they have to go to trial before Jim's team finds out like which lie are you alleging I told here?
no,
I mean,
because the response to that motion
would have to
would,
reveal.
would either be usually what you would have is, first you would have a motion for a bill of particulars, which is basically detail the conduct that you think constitutes the offense, right? If you get the bill of particulars, then you file the motion. This bill of particulars does not support
Right.
the
So
indictment.
dismiss. Yeah.
If you don't get the bill of particulars, then you file a motion to dismiss that said then you have to deal with the conduct in the context of that motion to dismiss, right? You have to explain to a judge, okay, here are the facts we're prepared to prove beyond a reasonable doubt to a jury. And that's when you would find that out, in the response to the motion to dismiss.
Right. Right. For what it's worth, and I mean, I think a lot of this is us just trying to read people's minds, which is, not going to get us anywhere. But I
As Dan
didn't.
Quayle once said of Lindsay Halligan, it's a terrible thing to lose your mind or not to have a mind.
Yeah, I went. But I don't necessarily read Comey's comment in his video yesterday as saying, let's go to trial and let a jury of my peers judge me. I mean, I presume that they will avail themselves of all of these, emotions and things that we're talking about. I think that a judge dismissing this case for whatever reason, he would count as a pretty clear victory. I don't think he's saying, I need a jury of my peers to say not guilty.
Okay, so two things. One is, I agree with you. There's ambiguity in that, and in no sense should you read Jim's comment as saying, I must win at trial.
Right.
On
Which would
the
be
other
kind of
hand,
crazy, just to be clear.
Jim is a careful lawyer, and he knows the difference between motions practice and trial.
Yes.
And he did choose to say, he could have said, I'm innocent, so let's have it out. Let's see where this case goes. And he said, let's have a trial. And I read that as at least holding out the possibility, you want to go to trial, Lindsay Halligan? Put up or shut up.
But Pat Fitzgerald is never going to advise him on that. He's going to say, Jim, we don't even have to go there. Let's do the motion stuff and then we'll be good. I mean, I'm just saying, I think we have to hold out the possibility that, Jim Comey put himself in front of a ring light last night and just said some things and don't necessarily hold him to every single word.
So I agree, although Jim is, among other things, a careful and smart lawyer.
That's true.
And
Absolutely.
I can't imagine he would have released a statement that was highly advised against by his legal team.
Yeah,
I just can't imagine that.
Daniel asked a pertinent question.
I'm not saying look for this to happen I am saying there are two ways to play this if you're Team Comey, and right. I would not be surprised to see them play it either way. One driven by the exigencies of taking Lindsay Halligan's pants down in court and making sure she never practices law again. And no, that was not a sexist remark. I would have said that, taking somebody's pants down in court is a gender neutral reference. I mean, there's a really good argument that Lindsay Halligan, this should be litigated in a way in which it is never possible for her to show her face in a federal court again. And also to give as many chances as possible to the courts to vindicate Jim's rights. That would be the conventional way to do it. But there's another way to look at this, which is this is a proud person who knows that this is an effort to drag him down into the, yeah, I got indicted for 90 felonies, but Jim Comey, who got me indicted for 90 felonies, which by the way is false. Jim got him indicted for nothing.
Yeah.
He got indicted too. There's just, criminals on one side, criminals on the other. You can't tell the difference. And it's going to be important to Jim to come out of this with a sense that one side played in a fashion that was counterfactual.
And went after his family,
Yeah, that was my question is, so Maureen Comey also has a civil case against the Justice Department that she's filed. And I'm wondering how the two cases could affect each other, or maybe help each other. Is that pertinent at all to either case, the other case?
Well, if you were filing a vindictive prosecution motion and you wanted to show that Trump's hatred of Comey was in fact vindictive and was the only thing that caused this case to go forward, it might be relevant to that you went after his daughter. That his daughter no longer works at the Justice Department, with no allegation, by the way, that she had done anything wrong, and that you hated her enough to fire her, even though that would exacerbate your Jeffrey Epstein problem, because she had been the prosecutor of Ghislaine Maxwell, right? Like, it might be relevant to that motion as part of your prima facie case that this is how much you are vindictive vis-a-vis Jim Comey.
It seems like it helps her case that they've charged her father now.
Oh, I think that's right, although she was fired by that point. So you could say that it couldn't have played a role in that because it hadn't happened yet. But look, this is what the military people call a target-rich environment. And, there's, I don't know.
I want to just spend a minute just stepping back for a second, because we're talking a lot about the mechanics of this particular case without even knowing exactly what he's been charged with. And I know everyone will agree with me, but we should say this. I mean, this feels like a watershed moment in the American justice system, right? Where a president of the United States, with his immense authorities and powers of persuasion, has managed to find a federal prosecutor who will go in and charge what all of her predecessors and colleagues knew was a bullshit case and try to bring a former FBI director to trial. Jim Comey is very well situated in this case to both defend himself on the allegations and has the resources to pay for all the excellent lawyers that Ben was just talking about. Most people who might find themselves in this position do not have those advantages. And what you're looking at here now is a situation in which the president has demonstrated that he will and can use the Department of Justice to successfully prosecute his enemies, which could tie people up in litigation that they cannot afford financially, mentally, professionally. They could lose their jobs, they could lose their homes. And that, I want to say, is precisely the point.
Yes.
That is what this is about.
And in fact, Shane and Ben, yesterday, did you see this executive order on domestic terrorism? Which to me is incredibly disturbing because it's so broad. And basically, I mean, I have concerns for all of us, to your point, that ordinary people, because they basically say that the executive order says that basically they're going to start going after domestic terror groups which they define as under the umbrella of self-described anti-fascism.
Yeah.
These movements portray foundation American principles as fascist to justify and encourage acts of violent revolution. And common threads in animating this violent conduct include anti-Americanism, anti-capitalism, anti-Christianity. Okay, so and that, by the way, I think what those of us on the progressive side of Christianity have been afraid of for a while now is that they hope to define Christianity in their very narrow political terms, and to make that point, will go after more progressive forms of Christianity or just anti-Trump Christianity. And then hostility towards those who hold traditional American views on family, religion, and morality. And then it continues on that the United States requires a national strategy to investigate and disrupt networks, entities, and organizations, and to intervene in criminal conspiracies before they result in violent political acts. To me, that's like Minority Report stuff. I don't know. I found it very, very disturbing.
So because of the Comey events yesterday, I want to foot stomp Holly's point. This executive order is a big deal, and it is a big deal, particularly in combination with the memo that went out about the Soros Foundation. This is an effort to go after sources of money that support particularly criminal justice reform type stuff. And it's an effort to harass foundations and to scare foundations into not supporting stuff anymore. There's also an Antifa executive order declaring Antifa a domestic terrorist organization. All of this is about hijacking the language of counterterrorism policy and applying it to domestic matters. Because of the Comey events this week, I have not had a chance to spend quality time with these orders yet. But Holly is exactly correct that this is a very important set of developments. And
on the same day, I mean, they're so haphazard, but is that coincidental? The same day Comey's indicted.
It's probably coincidental. This has much more to do with Charlie Kirk than it does with
and they
that.
And they specifically
but
mentioned
also, domestic terrorist organization, not a thing.
Right. Well, and also
and that executive order.
Well, actually, it is a thing. It's called the Proud
as an organization, not a thing.
How many executive orders statutes are cited in that executive order?
Right. So I will be spending some quality time with these three documents over the next week or so, assuming that we don't have an immediate follow-up with Letitia James to this. I want to say a word about Letitia James. Let me start by saying that I was very critical of Letitia James when she ran for office promising to go after Donald Trump. I thought that was improper. I still think that was improper. So I am, I'm not a fan of Letitia James, and she has played her own role in eroding some important norms. She did not commit mortgage fraud. Full stop, end of story. If you read the document that her lawyer sent to the Justice Department on this subject, it is completely persuasive. Now, Letitia James and Jim Comey are differently situated. Jim Comey is independently wealthy. He was the general counsel of Bridgewater, which is the largest hedge fund in the world. He was the general counsel of Lockheed Martin. And this is a guy who's like, whatever he may have to pay for his legal defense, he will do it, and it's not going to bankrupt him. Letitia James is not in that position. And so when you think about, I don't know what her finances look like, but let's just say she required a mortgage, which, when you're a public official and the federal government comes after you like this, and it is an effort to intimidate you and it is an effort to intimidate others. And, because they went after Jim first, a lot of the attention is going to be on Jim. But Jim is, unusually invulnerable to this stuff. Not be, he's a former Southern District prosecutor who is surrounded by other Southern District prosecutors. That's his close friend circle. And oh, by the way, he's got money. That's not Letitia James, and it's not Adam Schiff. Adam Schiff has a pardon, which may provide other insulation. But, the goal here, and the goal with Holly, the executive orders that Holly describes, is to intimidate people. And it is not fundamentally, yes, it is in the first instance about retribution against the Jim Comeys and Letitia Jameses and Adam Schiffs of the world. But fundamentally, it is about trying to intimidate other people, people who are in less positions to defend themselves and to assert their rights. And Letitia James, again, for whom my enthusiasm is under control, although I do want to say she did an excellent job in the substance of these cases that she brought. It was very wrong of her to campaign promising to go after Donald Trump. And, when that is that is an act of political and individual intimidation. And she is, and so look at these things as a collective. If you're a law firm, we will go after your business. If you're a university, we will go after your grants. If you're a student at a university, we will go after your residency status. If you're the former director of the FBI, we will bring a meritless indictment against you. If you're the Attorney General of New York, we will accuse you fraudulently. I use that word intentionally of mortgage fraud. We will show up at your house in a trench coat as a Justice Department official. These are acts of intimidation. If you're a senator, we will accuse you of mortgage fraud. And if you're anybody else, we expect you to get the message. And so my answer is, yeah, we got the message. Let's go out and do the shit we were going to do anyway, and do it with an awareness that these are evil people who are trying to intimidate you. And it is your decision, Shane Harris, as a journalist, whether you're going to be intimidated. And it is your decision, Holly Berkeley Fletcher, as a person who goes to protests semi-professionally for a living at this point, whether to be intimidated and go to fewer of them and be less aggressive. And it is my decision as somebody who runs an organization and does guerrilla protesting at the, let's just say, the margins of the law, whether to be a little bit more careful about compliance than I was a few weeks ago or a few months ago, before the Secret Service decided that chalk on the sidewalk is a violation of DC law. And by the way, on that point, it is your decision as a city councilman of the District of Columbia whether to change that law, to clarify that chalk on the streets is not a crime in the District of Columbia. The president has no say on that. Everybody gets to decide. That's all I got. Folks, we're going to be back on Monday. our special guest today, who appears to have had a traffic accident and will be with us next week. And we're going to be back because we're not going to be less aggressive. We're not going to be less loud, and neither should you be. And now I got to go talk to NPR. Talk to you later.